Okay, ladies and gentlemen, good morning. I suggest that we are going to start with this first panel on the Wednesday morning about mobile health. My name is Sjaak Nouwt and I'm from the Royal Dutch Medical Association, and we are organizing this panel with INNOVIRIS. We have 4 speakers in this panel and 1 moderator. The moderator is Eugenio Mantovani, here in the front. He will ask the panelists some questions after they have given their presentations in an introduction to the discussion with you. We, the speakers, will give a short presentation, 10 to 15 minutes, on several topics related to mobile health. I will shortly introduce them. On the right side for you is Nico Schutte. He is Senior Privacy Officer at Philips in the Netherlands. Then Peteris Zilgalvis. He is Head of the Unit for eHealth and Wellbeing in DG CNECT from the European Commission. And Annabel Seebohm is a lawyer and Head of the Brussels office of the German Medical Association, legal advisor of the legal department of the German Medical Association. She is also legal advisor for the World Medical Association and also advising members of Parliament, European Parliament. So we are going to introduce the topic mobile health to you. We originally scheduled that Joan Antokol was going to moderate this panel, but she is from the United States and she couldn't get to Brussels because of the snowstorm, unfortunately. And my colleague Marian Hoekstra would give this presentation by the Dutch Medical Association, but she is ill, so I have to replace her. So I'm sorry to be the one as a chair who also will give the first presentation, but just let's get started. I would like to inform you about an instrument that we have recently developed and that we will publish next week, we hope, and we call this the Medical App Checker. It's a guidance for doctors to evaluate mobile medical apps. Just to give some background information, what we're trying to reach with this medical app checker is to enhance or encourage the responsible use of mobile medical apps by doctors. Doctors use mobile medical apps or can prescribe them to their patients, for example. Hey, you should use this one or you should use that one. But how can they how can they evaluate whether this app is reliable, is working well, is user-friendly, etc.? So that's why we developed some criteria for doctors to evaluate mobile medical apps. Well, you know, there are a lot of mobile medical apps available, apps that inform, diagnose, or support diagnosis or clinical decisions, calculate, or decide on the diagnosis or treatments even. And there is a lot of uncertainty we noticed among doctors in the Netherlands about the reliability of those apps, the quality of these apps, and liability. What if this app says it's okay and the next day the patient is dead? Am I liable for not seeing that? So the medical app checker we developed is a guidance for doctors. It intends to make it possible to make a more qualitative evaluation of mobile medical apps by doctors. And again, not only for use, to be used by doctors, but also by patients or other relatives of the patients. And we have developed this in cooperation with several stakeholders in the Netherlands, doctors, app developers, patient organizations. We organized an invitational conference to discuss a draft version, and we made a final version that, again, we are hoping to publish next week. Now, the app checker consists of 3 parts. We have 3 checks. The first check is a targeted search for a suitable mobile medical app. I will explain this shortly later. The second is about evaluation of the quality of the mobile medical app, and the third check is an evaluation of the protection of security and personal data. And after carrying out these three checks, a doctor, of course, wants to know, okay, is this app reliable? Is the quality okay? Well, we have a kind of a statement in the app checker that we do not guarantee 100% certainty, because the doctor has to decide for himself what he thinks is important. You can imagine that the protection of privacy is perhaps not so well. It's kind of a negative check, but well, maybe that is not a problem in this case. So the doctor has to evaluate himself how important the checks is. Of course, for the app developer, privacy and security is of importance, but we'll see how far we can go. Now, I'll do the first two checks very shortly because they are not related to privacy and data protection. So the first check is to target, is this mobile medical app suitable for what you're looking for? Is it for yourself that you want to use this app? Is it the patient you want to use it, or for a caregiver? And a doctor should also think in advance about the functions that the app should have. Should it provide information? Should it be able to take measurements? Should it support in making diagnosis, in monitoring, behavioral change, or should it do something else? And so the question is, for which functions do you want this mobile medical app? So that's the first check that the doctor has to do. And the second check is about the quality of the mobile medical app. He has to check, for example, does this app has a CE mark if it is obliged, if it is compulsory. A CE mark is compulsory when a medical app is to be used as a medical device. So, well, it's very difficult to explain doctors when an app is a medical device. So we have two criteria, simple criteria. Does the app dispense diagnostic or therapeutic advice? Or is the app intended to enable the use of a medical device? If one of these answers is yes, then a CE mark is compulsory. And then the third question is, only if a CE mark is compulsory, does it really has a CE mark? Because if it doesn't, you should not use this app, because you are using a medical device that does not have a CE mark. So that's not safe. That's what we advise to doctors. We also check the functionality. Has the functionality to the extent to which the app, that is about the extent to which the app provides the function that you're looking for. Is it to provide information, to take measurements, to support diagnosis, monitoring, etc. And so has the functionality of the app largely been, when the functionality has been largely negatively reviewed on a review site, that's also an indication that you perhaps better not use this medical app. Another aspect of the quality is the content quality and the clinical relevance. This is about the extent to which the content of an app meets medical criteria, and if necessary, the doctor can also look on a website related to this app to get some more background information, for example. So these are the questions more of a medical content aspect that the doctor should look at. And another point of the quality of medical app is the ease of use. He has to ask himself a number of questions about how easy it is to use this app. Well, that's also about is it explained, but also can problems with the use of the app be reported to the app provider, for example? Does it has a phone number, email address, etc. Now this is for us here not so very interesting, perhaps. Now the interesting part is more about data protection and security. And we have worked together with a colleague of Deloitte, who has developed a privacy and security check test for mobile medical apps, and they were also they also gave input to this app checker. When it comes to privacy, it's of course very difficult to ask from doctors to make a very thorough privacy impact assessment of each medical app, but we can give them some questions that we think they can answer. So the first question is, for example, does the app include a clear, easy-to-read privacy statement? You can ask a doctor to check this. You don't have to be a data protection specialist for that. And if the answer is no, well, the use of the app is not advisable. We don't say do not use this app, we advise not to. Okay, so, and second question is, does the privacy statement do anything of the following? Does it have information about the following? Does it ask permission to collect data? Does it ask access data on your mobile device, like your contacts or your location, etc.? Does it use any data about has the information about the use of any other data which is entered or released in the app? Does it delete the data entered, including the account data, for example? And we say that, okay, if two answers are no, then the app is not advisable. So an app, you might say that an app does not need all of these functionalities, but when two answers are no, the app is not advisable. Now, when it comes to data security, it's also very difficult for doctors to check how the security is arranged. So one of the most easy parts is check whether an app has been subject to testing on security by a third party. So in that case, it shall have a certification or a statement that the app has been checked. The developer will, of course, mention that in his app or on the website. So you can check that. And if it does not, you can ask yourself, does the app include a security policy? Or does a security policy include information on setting up secure access, securing electronic communications through the app, if the app uses a portal, for instance by using HTTPS in the URL? And if two answers of these questions are no, the use of the app is also not advisable. So that is how we developed the app checker, including some privacy and security checks. Not only privacy security checks, because it's also about the quality and about does the app does what you want it to do. But I think for this, the privacy security check is most important. And if you like to receive from us, we also have an English version of the app checker. So if you want to receive this from us, including the press message that we will publish next week, please send us an email with your name, your affiliation, your country, and your email address, and we will happy to send it to you. I hope next week. So one of to Marian or to me, and that's what I want to inform you about our medical app checker. Okay. Okay, now as a chair of this panel, I would like to give the floor to Peteris.
Thank you very much. I'm sending you an email to say, please send me the medical app checker. This is very interesting.
Okay, thank you very much.
So now that that's done, I can start. Do I have the instrument to control my slides? Thank you very much. I can't control everything, as we all know, but at least I can control my slides, hopefully. They're not there yet.
Bye.
There it is. This is fine.
Yeah.
I should know what I'm saying, but I'll just take a look at which slide I'm showing on the screen. So starting with the content, I'll talk about the General Data Protection Regulation and its future impact on healthcare. A little bit on personal data relating to healthcare. Excuse me, I've gone ahead. The follow-up actions to the Green Paper on mobile health. What the Code of Conduct is, where we are now, the structure of the code, and relevant topics for the discussion here today on data protection in the code. Now, on the upcoming General Data Protection Regulation, its impact on healthcare. I mean, there might be expertise in this room that's even beyond mine, so I'll try not to go too deeply into this. I think, as you know, data protection is a fundamental right in the EU, different from some of our trading partners for whom it's more of a consumer right. Personal data are sensitive data. I think it's very much a step forward, which my unit and I pushed for, that in the regulation, health data is taken out from just being together with the other types of sensitive data, because in our point of view, health data is different. The citizen generally wants to prevent it just being freely available in a personalized form everywhere, but they want it to flow freely for treatment in their medical care, for instance, and often want to make sure that it can be used for research. There's specific provisions on processing for health purposes, as well as on historical, statistical, and scientific research purposes, which again is very important for the provision of healthcare and the overall well-being in our societies. Processing is legitimate if necessary for public health purposes, given that provided that member states adopt sufficient safeguards, which is a new requirement. The GDPR requires member states to provide such rules, for instance, for cancer registries. Consent of the individual is not always required. Where important scientific research purposes can't be accomplished with anonymous or anonymized data, processing of personal data should be authorized. However, anonymization, or at least pseudonymization, should be utilized whenever feasible. So now the Green Paper on mHealth is our policy document on mobile health. We issued it and had a public consultation asking some questions. We asked stakeholders about data protection and security, big data, the legal framework, patient safety, about mHealth's role in healthcare systems. These are comments below that we received. Some of the stakeholders were saying that safety and performance requirements of lifestyle and well-being apps should be covered by legislation. So the ones that are not a medical device, and probably actually the majority of them. At our latest count, there's now 165,000 health apps, broadly defined. So the number is going up and up. The number that are classified officially as medical devices might be about 20 or a little bit more, but in any case, it's not a huge number. That number will rise, I think, fairly rapidly, but you'll always have a much greater number which are not classified as medical devices. We heard that there was a need to clarify the border between medical and lifestyle and well-being apps, something we just heard. It's not so easy always for a doctor, and I think it's very helpful, this medical app checker, that you have a, easy question that a doctor can look at to see if it goes into this category. And the need for strengthened enforcement of medical device and data protection legislation, because it is very clear to many stakeholders that there are real medical device apps on the market that have never been approved as medical devices and are giving diagnostic and other types of results, often without, valid results being provided. And in the area of data protection, I mean, it's a little bit anecdotal, but I think the Financial Times checked the top 10 fitness apps, and this was, I think, about 2 years ago, but I don't know if the situation's so different now, and 9 of them were selling or giving data to data brokers, and this was not clearly explained to those using the apps, and that was also about the time of this consultation, so that was definitely true at that time. So on privacy and security, what are we going to do? We have a code of conduct on mobile health apps, which we're facilitating. It's important to underline. It's an industry code utilizing Article 27 of the current Data Protection Directive. There's a similar article, changed numbers a couple of times, so I won't cite the number to you, but there's a similar article in the new regulation which actually gives more importance even to the codes of conduct. So we have an industry drafting group who kind of selected themselves, but the Commission is providing a rapporteur and legal advice to ensure that this is in line with our reading of the directive, and also we're trying to adapt it to the regulation. The industry group is quite interesting in the sense that obviously you have European participants, which of course is absolutely necessary, but it also extends to Apple, Google, and Samsung. So in a way, it's a very global code, though the scope is just Europe, potentially in discussions with Asian countries and with the United States and perhaps others. We could have some sort of at least informal application also for apps, not just in the European jurisdiction. So further, the objective is increased trust, raising awareness and facilitating compliance with data protection rules at the EU level, a competitive advantage for those app developers who say, we've signed up and we're following this. We're not in any way, or they're not more precisely rewriting the data protection directive. They're giving a little bit more specific advice for the area of mobile health and for apps. Obviously, anything that's in the directive and anything that will be in the regulation when it's in force is what is binding. It's a process and industry code of conduct working group with the EC as facilitator, and very important in the first part of this year, which is coming up very soon. It should be presented to the Article 29 Working Party, the data protection authorities of the member states for their approval. So where are we now? Right now we're in this stage, wider distribution to other stakeholders. It's public, so anybody who hasn't seen it can get it. It's on our website or write to me on my email, and I'm happy to send it to you. The drafting team will include the comments received in the text and update the draft before sending it to the Article 29 Working Party. We're literally in probably the last days or weeks of being able to do this, so if you have comments, please send them. And of course you can tell me also today. Its focus is on apps that process data concerning health. The scope is wide. It goes all the way into kind of the fitness area if this data would be used for health. And it also covers medical devices apps, because in relation to privacy, there's not a difference whether it's doing diagnosis and it's validated as a medical device app, or it's just counting your steps. The duties on privacy are the same thing as long as it's classified as health data. No new terminology or definitions. Lifestyle data, this is what I was saying, can be qualified as data concerning health when they have a clear and close link to the person's health status. Examples and references are in the text right now to illustrate the gray area. There are practical guidelines for providers, a privacy impact statement assessment, accessible and easy to read, examples of information notices that can be used. On consent, we're encouraging, or they're encouraging, fine-grained and tiered consent, privacy by design and by default, data subject rights, transparency, summary of the obligations, draft notices, and policy generators, security principles in the code, privacy by design default, also security by design and default, mock data testing, incident management. If there is an unintentional leakage of data, if there's an intentional leakage of data, then this should be known as well. That's a different question a little bit. On advertising, always consent-based, but there's a distinction between contextual opt-out and personalized opt-in. On secondary processing, big data, the central role of compatible processing is emphasized. Acknowledging historical, statistical, or scientific purposes, again, in a society, in a well-being and solidarity-based society like ours in Europe, or societies, it is very important that you also have the ethical imperative to advance medical research and advance the overall well-being of the society. But obviously the individual always has the right to say no. Pseudonymization and anonymization. On data disclosures, transfers, and breaches, use of sub-processors for technical or substantive processing, transparency, contractual safeguards, including security, also transfers on mechanisms to third countries, data breaches, operational guidance, and pointing to national laws. Also, I mean, in this area, the Network Information Security Directive was just adopted. At least negotiations were finished on that, but that won't be enforced for a while now. On adherence and governance, this section remains to be discussed, and also in this audience I can raise the, problem of this, and your inputs are very welcome. The way to actually govern it, it's not the duty of the data protection authorities or the European Commission, whose duty it is to enforce right now the directive or later the regulation. Obviously, if something's a violation of a code of conduct, that's also a violation of the directive and regulation. Either the European authorities or the national authorities will act in the proper cases, but it is not our job to enforce, compliance of a developer with an industry code of conduct. So there should be a governance mechanism. The industry group is being a little bit hesitant on setting it up. We think the data protection authorities at Article 29 will demand it, again, because we're facilitating it. We're not in the position of saying you must do it this way, but that's something that still needs to be developed a little bit. Something that we're in absolutely full agreement with the industry on is that it should not be an onerous obligation for the signatories, because let's say many of them could be very small app developers. We all know that it could be one young man or one young lady who's developed an app and put it on the App Store, and they shouldn't have to pay €500 to be a signatory to the Code of Conduct and have to come to Brussels to some kind of meetings. So there should be a light way for them to join and, make a minimal contribution, if any, to the governance. But obviously you have big actors like the app stores, who are a couple basically distributing all the apps, which, now speaking a little bit personally, I think could make a contribution, but we'll see how that negotiation goes. Possible options, as you say, self-declaration with or without audits, third-party verification, trust labels, a central body taking charge. So in all these cases, I think it's important that it's not an obligation that would scare away app developers, but at the same time, it does have credibility. And so then that's someone who's not me saying thank you. Well, I'm saying thank you for your attention. And then there's my email address and Twitter account if you want to contact me about any of these issues that I've raised today. Thank you for your attention.
Please keep your questions until the discussion. And in the meantime, we will listen to Annabel Seebohm about the European doctor's opinion on mobile health.
Thank you, Sjaak. Good morning, everybody, and thank you for the invitation. I'm happy to present to you today the European doctor's opinion on mHealth on behalf of the Standing Committee of European Doctors. Talking about mHealth, promising pictures emerge. I took them from your website, actually. And it's always related to the so-called triple win. It's a win for the patient in that he might get quicker diagnosis and a better treatment. It's a win for the system. It might be related to cost reduction. Data might be generated, which might be valuable for medical research. And it's a win maybe for the market, because the market volume increases a lot. And I think this needs to be discussed thoroughly, whether it's really a triple win for everybody, and it needs to be, all the interests need to be weighed in a way. Let's put this into a context. In 2011, the cross-border directive entered into force and established the eHealth network. And so I guess this is where also discussions started around mHealth, and it's been first addressed in 2012 in the eHealth Action Plan, and then followed by the consultation in 2014. Then last year in May, I think it was, the Digital Single Market Strategy was released, also addressing the importance of mHealth in relation to standardization. So there might be potential to also standardize mHealth. And just in January, a consultation closed on the relevance of standards concerning mHealth. And CPME took part in these two-letter consultations. I'm going to show to you what they said, what were their responses, and they built a policy around this. Now, in the consultation in June 2014, the answers pretty much singled around 7 points. First one, Peteris, you also mentioned this one, is the legal gap, which was addressed that what should be done with the apps which are not medical devices, which don't fall under in the scope of the medical devices legislation, what to do with them and how to differentiate them from real medical devices. Due to this legal gap, sort of vacuum evolves, so to say, what is really a safe and reliable health app and what is a quality app. And in order to ensure quality, CPME suggested some kind of certification mechanism. And also, CPME addressed that still legal uncertainties will remain when it comes to liability questions. Because if a doctor cannot really rely on a safe app or using a safe app, who will be liable, and will he probably not use it then? Of course, data protection is paramount. This has been addressed as well. There should be no third-party access, and there are questions raised where it's going to be stored, these kind of data. And in view of data minimization, one might also ask, is it really necessary to process data further than it's really necessary, just not keep it within the app, possibly, or within the software, not going to process to another company. Also, CPME at that time addressed electronic health records, that might be an additional potential to link data from mHealth apps to electronic health records. But then the question arises, what is really relevant? What is the clinical relevance of such kind of data being linked into electronic health records? And it's not just meaningless data causing confusion. And also, of course, CPME addressed the buzz or the potential of big data. When you talk about big data in terms of medical research, there is potential, of course, but one would need to keep up the ethical standards. And in view of CPME, informed consent, not only for giving consent into treatment, but also in the processing of your personal data, is a backbone principle. And you should only, if it's not possible or it's even impractical to obtain informed consent, then you would need to have some alternative, which is governance structures. And looking at the current version of the GDPR, the General Data Protection Regulation, this discussion about governance structures is pretty much left to member states in order to set up these kind of governance structures. And CPME advocates that ethics committees should be involved in this, and other institutions alike, to oversee such processes. Now, the Commission, you have already mentioned, that took up all the responses, and I've just found a very nice summary presented by DG Connect last summer. They took up all the concerns and reported on them. And then the second consultation, which was running in January, or until January, was about standardization and the potential for mHealth, and also CPME took part in this. And as you can see in the bottom, two domains were identified as key priorities for ICT standardization, which is quality, to have potential. There is potential for standards and having on quality criteria for health and wellness apps, and also for security and safety of mHealth apps. Now, I guess the Commission is still collecting responses, and then we're going to see what's coming out.
It's closed.
It's closed,
Yeah,
and
so the communication and the results are on their way.
Wonderful. So we're excited to see the outcome. Now, then the priorities from what I saw during the past months from the Commission side was certainly mHealth actions in the context of the digital single market, as I presume this will be singling around standardization, and the secondary use of health data in terms of big data, which is a question of data protection. And this was something presented by DG Santé, and by DG CNECT you can see the same, the code of conduct on data protection. Then there will be guidelines on the reliability of data, and there will be European standard on quality criteria for health and wellness apps. So my personal impression is that the focus will be on the next couple of months on data protection, certainly in secondary use. And as you said, there is this code of conduct led by the industry. And of course, I'm asking myself, so who's taking part in developing this kind of code? And it is industry-led, which makes sense in a way because they have to apply it, the developers. Yet again, there are also users' perspectives, which have different perspectives. So it's a bit of a more market-driven approach right now where we are. This also applies, I think, to standardization, because it's this old saying, whoever has the standard has the market. Again, it's a bit of a market-driven approach from my perspective. And I think it's important that potential effects on healthcare and healthcare systems, because we'll experience that with mHealth, need to be anticipated from all perspectives. And this is why also CPME has developed a policy at the end of last year, pretty much basing on the response given to the consultation in 2014. And it's about 8 recommendations. The first one is if you can't rely on the safety of an app, be cautious. The second one is mHealth app is not meant to replace a medical consultation with a doctor. It's meant to be a complementary tool to patient care. Then, of course, a regulatory framework should be in place at European level in order to delimitate mHealth services which have a medical purpose from those services having a sole well-being purpose. And of course, mHealth apps having a medical purpose should be considered as a medical device. Then it is important to clarify doctors' liability when using mHealth services, otherwise they might simply refrain from using them. Then data privacy and data security are paramount. Also privacy principles should be embedded in the design and architecture of mHealth apps already during the conception phase. And again, the potential to integrate data generated by mHealth apps and medical records may benefit care, provided it's about real clinical and useful data. And the use of the data should be medically proper and ethically sound. Now, coming back to the initial win-win-win look at things, I think one would need, in order to have a win for systems, in order to have a win situation for patients, one would need to ask questions. And you can ask questions in a positive and in a negative way. And I think it's the challenge to find the balance and to get to the positive side of the questions. For example, do mHealth applications have the potential to a real medical benefit fostering patient safety? And there are examples that this might be the case. Do mHealth applications have the potential to alleviate access to healthcare? Thinking about remote areas, that might be very helpful. Do they have the potential to improve patient empowerment and interaction with doctors, because it's just easy to use and you can get in contact very easily? Does it might lead to cost reduction even, because some things can be done via such a service? And does it have the potential to meaningfully use generated data for medical research in terms of big data scenarios, provided it's done ethically sound? You can also encounter those questions in a negative way, in saying, well, there might be applications which are medically unsound, endangering patient safety. And this is certainly something which would need to be made sure that this is not the case. It might even deteriorate access to healthcare, in that it's said, well, first consult this app thing and then you can see a doctor, which might in the end even lead to some sort of digital substitution, and in the end to, well, this is a really spooky perspective, to multi-class healthcare systems, in saying that, well, to see a doctor, that costs much more money. First you need to consult all these kind of devices or applications. This might then even lead to cost increase because the services of doctors will reduce, and when you reduce services, they get more expensive. And ultimately, all of us know about these examples. Does it have the potential to data misuse? And I guess it's the challenge to strike out the negative questions, and I'm happy to discuss this with you, and thank you for your attention.
Thank you very much, Annabel. We then finally going to listen to Nico Schutte, a privacy officer, senior privacy officer of Philips Consumer Businesses. I'm gonna presentation. Yeah.
So thank you, Sjaak, for the invitation. It's my pleasure to speak to you today and give you an industry's perspective. So, as Sjaak already indicated, I represent the global consumer business of Philips as privacy officer. So when I speak of privacy by design, it's not for medical devices, but it's for health products and also our regular consumer products. I'll take an outside-in approach. First, tell you something about some of the trends that are affecting our company, at least to the extent relevant for the topic. Then speak of the general control structures and processes that we have in place to establish privacy in a good way in our company. And then speak of the digital activation process. This is the process whereby we create new mobile applications and also new connected propositions. A connected proposition being a physical product in combination with an app. In the middle of the circle you find the products you traditionally know Philips for, the consumer products, audio, video, television, shavers, lighting, etc. One of the big trends that we see in Philips is that we go more and more connected. So we would still have the same ranges of products that we're selling, but at least the flagship products, the more interesting ones, are becoming connected. This is because we want to escape what we sometimes call commodity hell, which is where you compete with your products without any special features against Japanese or also Chinese manufacturers. We cannot win anymore on price, so what we need to do is add features, add functionalities that make the product interesting and with which we can also command, of course, a premium price. And there's a lot of advantages that come with this. Of course, if we have the proper permission of the consumer, we can also use the sensors in the devices. Another very important advantage is that we can improve the product when it's already in the market. So if we should later want to add any features or find any issues, we can still remedy them. Having said that, any product that we launch to the market must of course be secure and offer proper functionality, but still it's an advantage that with a connected proposition you can often go to market a little bit sooner. I have a few examples here. One is, for instance, a connected coffee maker. You find your favorite recipe online, download it to your machine, and you get a perfect coffee just as if you're a professional barista. A connected toothbrush for children, stimulating them to brush 30 seconds in the 4 quadrants of the mouth, and to really do that twice a day by having an engaging cartoons. A connected air purifier. Imagine living in Beijing, very poor air quality. When you're in your car, you can check air quality in your neighborhood, but also in the house. Put on the machine in advance and get home to nice, clear air. Connected baby monitor. View your child on your mobile device. Enables two-way communication. And in the future, it may even be used to analyze sleeping patterns and give advice to young parents. A connected pain management device. The device goes on your back, and actually your mobile phone is just the machine to which you, or the remote control with which you operate it. More interesting for the topic at hand is at the bottom right, it's a symbol for what we call heart health. It's a wristband, but also other devices like a scale for weight, etc. can be connected to it. People can set certain objectives, what is it that they want to accomplish, and then the system gives feedback either via algorithms or at the later stage even via human coaches. So the one trend is getting connected, the other trend is towards more and more health-related products. At this moment even our sector for the consumer business and the healthcare business are being merged, so we also get a lot of expertise coming a lot closer on medical devices, etc. So also the consumer business will move more and more towards medical. And our lighting business is even being set apart and sold off. So some big changes in the company at the moment. So what do we have in place then to manage privacy? First of all, we were the first company to have binding corporate rules. And through these binding corporate rules, we establish a basic level of privacy throughout the company. So we have training that we organize at group level, awareness. We have certain tools and methods that we deploy consistently throughout the company. Another very important element is also the central program organization. So when we have gaps against the binding corporate rules or when new legislation comes out, we also do a gap analysis. It becomes part of a central program and then we drive our improvements throughout the company. The third important element is the privacy impact assessment, which we really have deployed everywhere and use very consistently. Wherever a significant amount of personal data are processed, we make a risk assessment by experts. So we really take an in-depth view of where things can go wrong and where we need to put certain measures in place. And this results in a mitigation plan. So certain risks can be avoided, certain ones can be mitigated. And then it is signed off always by an executive in the organization. And the executive makes a formal trade-off, saying, well, I understand that wherever we process personal data, there is a risk involved. But I take ownership of these mitigations. I realize that whatever we do, there's still a residual risk. And I've made a careful trade-off. What is the risk to the individual? What's the risk to Philips? And also what is the benefit to the individual and benefit to Philips? And he signs for that. So in that way, really establish clear accountability at the executive level for any product, application, database or initiative that we deploy. Then there is the end-to-end program. We are reviewing, optimizing and harmonizing all of the processes in our organization. And wherever we've identified up front that personal data might be processed as part of a certain process, also as privacy we're involved and we can put requirements in place or controls. And also important, close relationship with other compliance areas. So I work intensively with product security and information security. We do consider it a different area of expertise. I know a little bit about it, but I'm not the expert, so make sure I get that expert involvement. Then our privacy by design process. The process that we have for creating a connected proposition or a mobile app. There's a little bit of history here. It started with an incident we had in 2012 with a website. It was a website from a company that we purchased, but it wasn't part of a good lifecycle management process, and we ran into some difficulties there. So we centralized everything and put proper controls in place, and then the logical next step was to also do that for mobile applications. I guess the first and most important thing is to really centralize and standardize. Because we came from a situation where almost everyone in the company could call a small agency next door, ask them to prepare or to create a mobile application. And there were even, I think, about a dozen licenses to put these into the App Store under the Philips name. So we created one process and a policy, made it mandatory for the entire company. We restricted access to the App Store to one account only, so we would centralize it and make sure that everything went through this one process. And the process combines compliance in terms of security, privacy, brand, and a few other areas. So what does the process look like? A first step is to create the minimal viable product. This is what I mentioned earlier, a product that has good, adequate security in place and at least basic functionality and is ready to go to the market. But when we enter this first phase, we already ask of the business that they have plans for the next cycles and also budget for the next cycles. So it's really not a one-off. The app needs to be managed throughout the life cycle. When we enter that process, again, in that process, we have a lot of standardization. Firstly, where possible, we try to work with standardized and validated components. So if an app would allow you to make a purchase in an app store, then this is a component that has been separately validated and then becomes part of the app. When you want to use it to do ratings and reviews, you take that component and make it part of the app. You can understand if you use standard components, then the evaluation that you have to do in the end becomes a lot simpler. We also have one backbone that we use for all of our apps and connected propositions, and also that backbone, the entire the system architecture that's behind that is standardized and validated, so we don't have to redo that every time. We also have a standard process for the PIA, the Privacy Impact Assessment. This is a trimmed down version of the one that we could use in any situation. So it's trimmed down, targeted really for mobile applications. And we also automated it to some extent. So when you ask certain questions, let's say is a third party involved in the processor, then the standard mitigation will also be to put the proper contractual agreements in place. So some of the mitigations are automated automatically, although still the privacy officer will review and of course create the full report. And then, perhaps one final thing that is that when you have a connected proposition rather than just an app, then of course you have a process by which you create the hardware and you have the process for the software. We make sure that these work in concert. About this PIA that we trigger, perhaps it's good to give an example of some of the questions we would ask, using that personal health program as an example. We'd look, for instance, at the functionality. So we have sensor data that's being collected, people set a certain objective in the system, and they get feedback on how they are performing. We look at the setup, where we have the wristband, there's an app on your mobile device, and there's a cloud service where the data is stored, and another element that does the authorization. Look at the kind of data we process, so heart rate, blood pressure, galvanic skin response, so how much is your transpiration, could be location, a questionnaire that's given to people, and then where are the considerations for privacy and for privacy. So what is the legal basis for processing? Usually explicit consent. How have we organized data retention? So how long can we store the data, when we should give people the opportunity to have the data removed or to leave it. For instance, if we use the service for 3 months and you pay for it for 3 months, should we then delete it immediately afterwards or not? Because people could re-enter the service at a later stage. So these are some of the questions that we look at. Access for employees or third parties. We always want minimum access. Everyone gets the access that they need to do their job, but no more and no less. People should be trained as well. We need to make sure that people are able to exercise their rights. So they need to be able to contact Philips, ask what data we hold of them, and also ask for corrections or for data to be deleted. Age is a criterion. You have legal ages that differ vastly around the world. For instance, in Iran, a 7-year-old girl is considered to be an adult, whereas in Singapore, you need to be 21. So what age do you choose in a global deployment? And aside from the legal age, you need to have an age where people can understand the service, be able to understand a privacy notice. End-to-end security, as I said, this is a different compliance area, but we involve our colleagues and we want to make sure this is properly taken care of. And storage, where will the data be stored, where will it be accessed? So these are some of the elements that we consider and to which we want a good answer before we can release an app or a connected proposition. So this is what I wanted to share. My email address is there. Don't hesitate to reach out. I'll be glad to tell you more or answer any questions. And then I think I need to hand over to the moderators.
Yeah. Okay.
Thank you.
Thank you. Okay, that's so far the presentations of 4 speakers, and now I would like to give the floor to Eugenio Mantovani to give a short introduction before we go to the discussion.
Hi everybody. So a quick comment. I think the news was this code of conduct, proposed by the Commission, privacy and mHealth. So let's start from that. The code is a form of self-regulation. It is a voluntary instrument subject to stakeholder consultation. It will be approved by the Article 29 Working Party. Now, it's a form of self-regulation, and as any form of self-regulation, it's meant to build some accountability, more accountability, and consensus around an area of promise, but also uncertainty as mobile health technology. Most importantly, a code of conduct should add something more. It should not just repeat what the law says. In fact, it's an instrument for, it's not a traditional command and control instrument, but it gives also the regulatees, the actors active in a mobile health technology ecosystem to actually participate. So my first question would concern the code and the compliance mechanism. Some committees, doctors, the World Medical Association, or also French doctors have pointed out that there is a sort of information asymmetry between the patient or the user of an app and the app developer. In order to mend this asymmetry, they think that a compliance mechanism, a third party, who is in charge of checking the compliance of an app with a code that is voluntarily abided by, is necessary. So my question would be, what are the options for this compliance mechanism? Would that be an European body? Or should be at national level, a public body or a private body? Again, under which framework? Data protection should be managed by data protection. Under the data protection framework, can we imagine the future European Data Protection Board as having to check the compliance of apps? And what about the resources? During the consultation, the European Cancer Patients Association proposed a mechanism similar to the European Medicines Agency. So say why app developers do not chip into a third-party compliance mechanism, and this third-party compliance mechanism, such as the EMA, would accompany the app developer in developing an app that is consistent with data protection and privacy rules. So first question about compliance mechanism, and you're free to chip in. Do you want each of you to answer to this question, or you prefer me to throw some other questions at you?
Well, just very briefly, I mean, there was the slide with the various options, that it could be audit-based, that it could be just declaration-based, that there could be a governance body. As I say, for the Commission, because we're facilitating it, it's not up to us to decide, but we expect that Article 29 will have some requirements to give the code some kind of teeth. And we can already kind of withdraw probably the possibility that the DPAs, the data protection authorities, would do it, because they check compliance with the directive and later with the regulation, not with a code that some people are declaring they're in line with. So I mean, it really would have to come from the app developers, or more broadly the ecosystem, the bigger industries and the app stores, for instance.
May I ask a question?
Yes.
But this is the code will be checked by Article 29 Working Party. So why is it not possible then that there is a robust sort of body like the Data Protection Officers, since they are involved via Article 29 anyway, to serve as this control body? Is that not possible?
I mean, there could be. It would have to be financed and set up by the signatories of the code or the surrounding industry. I mean, at least at this moment, it's, I think, not conceivable that there'll be a new European agency set up. And I would also not imagine, though of course nothing is possible, you could have 28 national decisions that we want to provide money for national agencies or an agency. but more likely the model that you do see in other areas, advertising or the cloud code, which is still under discussion, and some of you might know more about that than even I do, is that there should be a body set up for the code. It should have some kind of resources, but it is important, especially in the area compared to the cloud of the apps developers, that we don't raise high barriers to entry. You shouldn't have to become a millionaire to just submit an app to an app store. This should be something that the small developers as well as the more industrial developers can participate in.
So it's a question also of how many resources can you actually spend in a low, usually app developers, they respond to an economic model that is not the economic model of the millionaires. Can be also very small enterprise. So your concern would be, let's not create obstacles for these app developers and the compliance.
Excuse me, coffee break in 2 minutes.
2 minutes, okay. Thank you. Well, maybe we can take 5 minutes or 10 minutes because we started so late and have one coffee instead of 2. Are there any questions from the audience? Yes, here in front.
I have at least 2 questions. I had 3, but I just will make.
Start with 1.
Yes,
Okay.
The code of conduct, you mentioned it will not provide any new definitions. However, it talks about data concerning health, lifestyle data, and we know from the data protection side that there's not such a thing as lifestyle data. Everything is lifestyle data. Everything can be health data. It depends on the purpose of the processing it, which makes things very complicated. If you could say a few words on how do you think this could work?
Basically, we're working on the basis of the Article 29 opinion. So it's putting that in very simple instructions. And then I should add, very briefly, hopefully, to give the code and this whole area some teeth, I mentioned these other guidelines that will be on apps quality data that could be included in electronic health records. And finally, we're about to start a public consultation on all apps and non-embedded software, which is not covered by consumer product safety. So there could be action from the Commission to say not just specifically on mHealth apps, but also on 3D software, printer models, on blockchain, etc. Any non-embedded software that this is not functioning, it has to be taken off the market.
Okay. Anyone else for a question or remark? Yes?
I was wondering if you could describe in a little more detail what is meant by fine-grained and tiered consent. And of course, there have been some suggestions that you can only go so far with consent before it becomes impractical, and then you have a loud noise, and it just becomes virtually impossible for the actual data subjects to be able to grant consent for all the different cases.
Well, and this is for a specific app. So the citizen who's making the decision whether his or her privacy is sufficiently protected should have the information, what is being processed, for what purpose, what will happen to it, and you get the overall agreement that the data will not be sold or given to data brokers. So I mean, really specific on what this app does. And I think the latest statistics are that people do not use ever more than 27 apps at the same time. So it's a finite number. 27 sounds like a lot to me, but it should be fitting. I mean, this is looking at your sleep data. This is what we're going to do with it. This is the way we're going to store it.
Yeah. Also ask something. What about when it's about data concerning health? It's a real, let's say it's a real mHealth app with a real medical purpose. But then you would need to have express consent.
Yes.
Okay.
My
Your second question?
Your presentation about the checker for the application, I had the feeling that the questions about privacy and data protection were not as strong as one might expect for this particular scenario, which for me is the most important when a doctor is prescribing the use of an application. It really, for me, it implies that they're the strongest standards are being applied.
Yeah.
And so there were only a few questions, a bit random. So, did you have any input from the Data Protection Authority when it comes on the
Well, we based our questions on the Article 29 Working Party opinion about apps and consent, and that's the basis, and also the Dutch Data Protection, the Personal Data Protection Act, which has some obligations for providers of medical controls of medical data. But well, it was rather difficult because we think you cannot, as I said, you cannot ask from doctors to give a very thorough test on privacy and security issues. So what we try to is to keep it at a basic level and make it objective. Yeah? So you can ask a doctor, does the app has a privacy statement? Can you find some information about the security of the data in the app? So, the most important or most easy part could be when an app was assessed by a third party on the security measures, for example, and that's how you can recognize as a doctor, okay, this medical app has been tested by a third party and the security is okay. So, and that's, if I may transfer this remark into a question, also how to Peteris, for example, how can a doctor or can a patient recognize a medical app that it is safe on privacy and security issues? For example, have there been thoughts about it? Because it would be the easiest way, I think, that he can find a remark that this medical app is in compliance with the code of conduct, for example.
And that would be the idea, that there would be a declaration and either audit of all or some of the apps, and then that could be a way, for instance, in your app checker, has this app declared that it's in compliance with the code of conduct? Yeah. And there's a second enforcement mechanism, which is if you say you're in compliance of the code of conduct publicly on the internet and so on, and you're lying, this is fraud. So you're also liable for being prosecuted for fraud beyond the data protection violations by the regular authorities for commercial fraud.
Yeah. Okay, that's clear. Yeah. Okay. Any other questions? No. Eugene,
Well,
one last final question before we
yes,
go to
the last one. I have. Yes, I had a question. Well, one is about. Let's do the simplest one. Yes, it is about the advertisements. I mean, in the code of conduct, it's suggested that it's possible to place advertisement without the consent of the person using the app, when the AD is not the result of the processing on personal data. That is, when the AD is not the outcome of targeted processing activities. Whereas, when a ID is posted, so to speak, not randomly, but to that single application because it is related, for instance, its application having to do with the diabetes or glucose control, then it's absolutely possible. Don't you think that given that is, and I ask everybody, given the fact that we are dealing with the health, is quite dangerous to allow for this opt-out rule for general advertisement, even if it's not targeted, but many patients, maybe they are not well provided, or they may be misled by advertisements placed on their health or lifestyle app.
Patients or consumers. Nico, can you respond?
If you look at spamming laws, that's really about communication that's being sent, and then of course you always need to have the explicit consent. And we also make a distinction for an app whether the advertisement really pops up, or whether you could go to a separate tab and say, well, is there interesting information from the company? But wherever possible, we'd like to give as much choice as possible to the consumer, and we're not providing with advertising without the explicit consent.
So it's opt-in. You should opt in for advertisement.
Yes.
And I'm just thinking, when you think about, I'm talking about the real mHealth apps being a medical device, when you think about reimbursement models and you think about whether to introduce these kind of applications into SHI systems, I'm doubting whether it would work to link such applications to advertising. Have you thought about that? Have you discussed that?
I mean, in a more, first of all other legislation applies. So advertising, pharmaceuticals, and so on the internet and so on, it's prohibited the same way for apps or everything else. So these are things that are allowed. And in the one context, I don't know, this could be Mauritius is a healthy place. Everybody go there and you'll feel better. And in the other context where it's opt-in, it's okay, you are using a diabetes app, so now we're looking at things at diabetes. So there is a difference. And then further, and this is part of a more general observation, and I say it sometimes in presentations, we have to be conscious, the citizen, the consumer, the medical professional, that nothing is for free. Either the app will be paid by reimbursement, or it will be developed by the public sector, or there'll be an advertising model, or the citizen patient themselves is the product because they want to use your data. So, I mean, in the long term, as this apps industry develops, either people are going to have to start getting used to paying more, 10, 15, 20 euro themselves, instead of always counting on getting it for free, or it's going to be reimbursed, or you have to be conscious of what is paying for the thing is the advertisement or the use of your data. And I think the most important thing is that the citizen knows and makes an informed choice. But we cannot expect that app developers, who are people too with, at least later, even if they're young, have children and mortgages, they have to pay their bills, they have to get the money to carry on this activity. Something has to pay for this.
Yeah, but for instance, the CNIL, the French Data Protection Authority, has recently called for the suspension of an app for monitoring apnea during sleeping. And the reason is that the public health insurance would request the patient to show the data. So to show he actually is being using this app consistently and overnight, and be able to show quite intimate data concerning, I don't have a very active nightlife, but somebody maybe. So indeed, I understand that someone got to pay for it, but we may stumble across really the trade-off between privacy, health. You want some health, surrender some privacy. So I think I agree with you, but it may be more complex to actually implement concretely.
I mean, we definitely have ethical issues that, I mean, and then this goes beyond my unit or one person in the commission, that we as a society have to balance. As I said, I think there's general political agreement in Europe that we're a solidarity-based society. But, I mean, it's clear that this monitoring, whether self-monitoring or provided to you by your health system or your insurance system, is going to make it possible to penalize some people and give other people benefits by the way that they're living. And whether we allow this in the end is a political question.
For Philips, we at least take the perspective that we have the topic came up earlier, the granular consent, so people can always choose with whom they share data. There's some processing that's done by Philips or by our affiliates, so that's a different part. But if you want to share with a doctor or with a neighbor, whatever, then there's a separate consent needed for that.
Okay, having said that, I would like to thank the panelists for their contributions, and thank you, the audience, for your attention and your questions, and hope to see you again another time. Thank you very much.